developments in the lawsuit over the death of Gabby Petito. The 22-year-old vanished and was later found dead after going on a cross-country road trip with her fiancé, Brian Laundrie. Now, her family begged for answers and ultimately got them when Brian wrote out his confession before taking his own life.
Now, Gabby Petito's parents are suing Laundrie's parents. Yesterday, there was a hearing in the case as the judge heard arguments over a big piece of evidence known as the burn after reading letter.
Now, Court TV has actually obtained a copy of that letter, which the Petitos claim is proof the Laundries knew about Gabby's death while she was still missing. Now, the letter was written by Brian Laundrie's mother, Roberta, to her son, and it reads in part as follows. If you're in jail, I will bake a cake with a file in it. If you need to dispose of a body, I will show up with a shovel and garbage bags. Roberta Laundrie claims she wrote it before Brian and Gabby left for their trip in hopes of repairing her relationship with her son.
The judge ultimately denied the Laundrie's motion. They were fighting not to turn over the letter, and the letter was ordered to be turned over to the Petitos. Still with us, criminal defense attorney Joseph Tully. Joseph, what's your take on this? Now the letter gets to come in. What do you think?
Well, I mean, this is a really interesting case as well, because regularly in a civil law case, someone has no duty to act. Now, here the theory is that while the defendant, or who would have gone to trial, Mr. Laundrie, could have said nothing to police because he confessed to his parents, they don't have that Fifth Amendment right. They should have told the truth to police, and because they didn't do that, they're being sued. And this letter is going to be a huge part of that. They can prove that that the mother and father planned on, that knew that he was guilty and that were helping him. And so it really supports their claim.
Well, I'll tell you what, the mother claims, again, it was written long before Gabby disappeared, actually before they even went on this trip. And I'll tell you, Joseph, we keep hearing those couple of lines, which are both criminal acts, right, that mom's confessing to. But in the context of the whole letter, she goes on to say a number of things, like, if you flew to the moon, I would follow you, or I would be looking at the sky for you. If you did X, Y, and Z, I'd still be here loving you. It's really all about a mom telling her son all the things she would do for him. And when you look at the full context of the letter, you get the sense that maybe it was written for the purposes that she says. So ultimately, what do you think about the decision by the judge to let it go to the jury? They wanted to keep it out. But in looking at the full letter and not having a date on it, I think he did the right thing in saying, you know what, we're going to let this get in front of a jury, let them decide what its importance is.
I agree. A lot of times when judges have a decision that could go either way, in general, I think it's best to give it to a jury. It's 12 people, a jury of someone's peers, and they can, using reason, figure that out. I think you gave a great side in terms of what they will argue in court. Look, this is just a letter, and yeah, those lines are unfortunate, but this is a mother talking about her son, how much love she has for her son, and it's just lines together. But there's pretty good insinuations that those points were included that were very specific to what happened in this case.
Yeah, it kind of goes, Kelly, to what we were just talking about in the Bleefnick case, where he does these weird searches. Mm-hmm. And just weird searches are fine, weird searches, but when they're so coincidental to the crime at hand, it becomes problematic. Same thing here. You have a letter, a mom writing a bunch of things to her son, but it's just so coincidental that the things she's talking about relate to the facts of the case. Makes it difficult.
It does make it difficult. It is coincidental. She really explains this away, though, by saying this is a book. This is based on a book. Anyone who knows anything about the book knows what it says. It's about reflection, getting you to think about your thoughts, being able to put them down on a sheet of paper and then burn them afterwards, so maybe no one sees them. And that's what she's saying. That's why I wrote, this is the burn after writing letter, because it's based on this book that me and my son had discussed together. And Joseph, what's your take on her explanation behind this?
Well, I think, again, that's a good explanation, but I think what happened in court on this was that the other attorney, picked up those same books and scored some points with the judge and said, Judge, these Little Bear books and the other one don't mention anything about someone going to jail or having a file and a cake or having bags to dispose of a body. So there are some points to counter the effectiveness of this letter, but the letter will be very effective for the plaintiffs in this case.
Joseph, here's the other thing I wanted to ask you. You know, I wanted to know if you thought this letter would be admissible in a criminal case. Sometimes the rules of evidence are a little bit more lax in a civil trial because, of course, the stakes are a little bit different. Of course, the burden of proof is different. Do you think this letter is something that would have been allowed in a criminal trial?
So gut reaction is yes. And that's just because, and I'm not trying to be negative or cynical here, but generally speaking, if there's bad evidence against the accused, a general rule is that it's going to come into court unless there was specific evidence that could keep it out, such as more proof of when the letter was written or proof that it really didn't have anything to do with Gabby Petito's disappearance or her murder. I think it would be hard to keep it out of a criminal case. I think it would come in.
Interesting. And I wonder if there was if you look at that type of evidence and you say the prejudicial effect versus the probative value, you know, is it possible it might come under this hearsay type evaluation by the court?
Well, sure, and it's because it's not Mr. Laundrie's words that would be used against him. It's somebody else's words that would be used for great effect by the prosecution, and it would be highly prejudicial and not all that probative in terms of what the actual defendant would have been saying or facing.